Yes, Mr. Sinclair.
My Lords, I was on the first part of my submissions concerning methodology. I showed you the claim form and the Goss and Whitehorn methodology, which I explained. I now want to explain the approach Mr. Robinson is taking on the back of the industry evidence. Now, again, just taking this in stages, at the level of the OEM to NSC, so the first level of the supply chain, there is nothing which Mr. Robinson is doing at that level. He's taking the shipping overcharge and assuming it was entirely passed on from OEMs to NSCs. At the next stage, NSCs down to retailers, what he does is he says he's going to observe the next increase in the total delivery charge. So he's waiting for the delivery charge actually to be increased by the relevant NSC. And he's at that stage calculating that the shipping overcharge will be passed on. And also at this stage of the supply chain, as Mr. Dimitriou explained earlier, he is calculating the extent of the pass-on as the smaller of two amounts, so the smaller of that delivery charge increase or the overcharge. And with respect, that's an obvious point because you could hardly attribute more than the overcharge to the cartel. So it's not, we say it's effectively 100% pass-on from NSC to retailers, subject to two very limited qualifications, one being the time lag, and two, he is only operating to the level of the overcharge. If for some reason the delivery charge went up by more than the overcharge, he will take the smaller amount. So those are two limited qualifications, but otherwise it's 100% pass on at the second level of the supply chain. And there is nothing at the third level of the supply chain. Again, just assuming on the back of the industry evidence that it's 100% from retailers to customers. And if I could show you, just to make good the proposition that what BDO are doing to calculate the loss is entirely premised on the industry evidence. If I could just briefly show you, I'm just focusing on the first report at this stage because I want to take it chronologically, but Supplemental Bundle 1, tab 7. If I could ask you to turn to page 299, please. And paragraphs 5.2 to 5.6 are places where he explains, this is his methodology for computing the loss. But you will see at 5.2 to 5.6, the introduction to section 5 of his report, which is concerning that question, it's all premised on what the industry experts are saying. So 5.2, as stated within the industry experts report, and so on. 5.3, over the page, I understand from the industry experts report, this is how things happened in the industry. 5.4, one sees an extensive quotation from Messrs. Goss and Whitehorn. 5.5, the industry experts state, and 5.6 to similar effect. If one moves to 5.12 over the page, see the heading pass on through the supply chain, taking into account these factors and based on my understanding from the industry experts report. And then one sees at 5.15 the introduction to his illustrative scenarios, which we don't need to go to, but they are based on the industry experts report. And indeed, I should say it is common ground that the foundation for the BDO methodology, if one can call it that, is the industry evidence. To give you some references, but I don't need to take you to them, the reply of the class representative at paragraphs 52, subparagraphs 1, 2, and 3, which can be found at Supplemental Bundle 1, tab 4, page 154, they accept rightly that the methodology has been designed in the light of the industry evidence. They say it depends on the factual propositions, and they say the factual evidence of the industry witnesses provides the building block. So it's common ground that this is all based on what the industry evidence is saying. Now, I'd like to show you what we said in response. To pick up a point my Lord Justice Green was saying, what were you saying in response? Did you plead a defence? Well, what we did do was we served two short witness statements, making clear that the industry evidence is not accepted and will be hotly contested at trial. And I'll show you briefly the two statements. But I do stress that we were not asking the tribunal to conduct a mini-trial or make any decisions about the facts. And this is important because when I come to show you the relevant paragraphs of the judgment, we submit that the tribunal went wrong insofar as they proceeded on the basis that that is what we were asking them to do. This was not a mini-trial. We were simply serving the statements to demonstrate that what the industry witnesses are saying will be hotly contested at trial, and therefore the submission was, under the process test, the methodology needs to be able to grapple with a different version of events. So if I briefly show you the first witness statement, Mr. Cunningham, at Supplemental Bundle 2, at tab 13. And we've summarised the key parts of paragraph 24 of our skeleton, but it's a short statement, so I think I should show you the document. So Mr. Cunningham worked for Hertz UK, who purchased approximately 50,000 vehicles a year, and he says he directly negotiated with OEMs. So just pausing there, the supply chain analysis that we've seen in the industry evidence doesn't actually apply here, because Hertz, being such a major corporate purchaser, is directly negotiating with OEMs. But if one picks up the statement at paragraph 18, he said, in discussions with OEMs, virtually every cost item was negotiable. Halfway through the paragraph, I cannot recall any party being particularly interested in the delivery charge, but like other costs, it regularly formed part of the overall arm wrestle on price. The extent to which the delivery charge was negotiated would depend on the individual negotiations. In certain circumstances, Hertz would specifically refuse. And then if one turns over the page, paragraphs 20 through to 22, he says, 20, second sentence, the delivery charge was not a fixed fee, nor was it treated as one. How discounts were shown on the invoice varied between OEMs. And then you can see at the end of 21, the format of the invoice didn't necessarily reflect the substance. In other words, the delivery charge line item might remain, even if it had been negotiated down or away. And then 22, negotiations with each OEM would vary significantly. So that's Mr. Cunningham's evidence.
There were no exhibits to this. I'm not suggesting there necessarily needed to be. But this was the full extent of his statement.
Yes. I think Mr. Dent did have a short exhibit.
No, that's absolutely fine.
But no, but all we would do, it was a very limited
Understood.
purpose. Yes. And so Mr. Dent, who's behind the next tab, very different perspective, because he is a retailer, BMW retail sales leader. And what he was saying, if one picks this up, again, one can see it's a short statement. If one picks it up at paragraph 26.
Which tab are you in?
Oh, I'm sorry, it's tab 14.
Tab 14,
the next tab, yeah. Perhaps if one just looks at the heading, actually, on page 377 of the bundle, one can see the heading, Setting Car Sales Prices. And at 20, he says, while dealers have target margins, the price at which dealers sell cars to customers is influenced by numerous factors. This includes how the dealership is performing in relation to quarterly targets. And he talks about market share. Other factors that influence price include customer retention, future income from maintenance and repair, and the number of particular model that the dealer has in stock. Then he deals with negotiations at 21 to 23. And at 26, if I can pick it up, at 26, customers often question the delivery charge and ask for it to be discounted. And then at 27, he says, I do not believe customers were prejudiced by the fact that delivery charge. The second sentence, I tell customers that the delivery charge is included in the advertised price and cannot be discounted. However, on a number of occasions, I have had customers who've specifically focused on that cost. And your lordships can see the remainder of that paragraph. He's saying it makes no difference to a dealer where the discount is applied. It's physically impossible to change certain line items. In 28 over the page, whatever agreement is reached with the customer, the paperwork always contains fixed numbers, even if it was agreed that the options or delivery would be discounted or free. And then at 30, the retailer always looks to sell the car for more than it paid. The amount of special allowance that the retailer is willing to offer will depend on a variety of factors, including achievement targets, length of time the vehicle has been in stock, whether a new model will soon be launched. The special allowance...
So your case is the customer negotiates an overall price for the car that may include a discount, and if it does, that may either reduce the effective delivery charge or eliminate it.
Yes. Now, Ms. Dimitriou's submission is the claim fails because they're not measuring what the customer actually paid for the vehicle. My submission is the way this has all been put together in terms of the methodology is not looking at what was happening. at any stage of the supply chain. It is taking the industry evidence as read
Yes.
and saying, well, on the basis all of that is correct,
Certainly.
let's calculate the loss.
Yeah.
And we say, and it is a different point to Mr. Mitri's, because we say as a matter of the process test, which is unique to this certification regime, this is not an acceptable way to proceed. You may be able to fend off a summary judgment application by saying, well, we've got our industry witnesses and they may be right or wrong at trial. But we say under process, and I will pick up Lord Justice Green's dictum in the Gutman case, that the methodology needs to be adaptable, capable of dealing with different facts at trial. And that really is the core submission. It's not good enough, we submit, to turn up and say, well, this is how we want to run the case, and we'll see you at trial. What they need to do is propose a methodology that can deal with a situation in which their evidence is not accepted wholesale at trial. And that's the critical point. So we say, we gave a flavour, really, to the tribunal of what the case would be at trial, the facts would be at trial. That's the limited purpose of serving these statements. And then, no surprise, but how do Messrs. Goss and Whitehorn deal with this? Well, I don't need to go to the references, but they simply say in their second report, which is Supplemental 2, tab 15, well, we note what Mr. Cunningham and Mr. Dent say, that doesn't accord with our experience. So they make plain in their second report that there is a dispute as to the facts. And then, and this is critical in my submission, what does Mr. Robinson of BDO say about all of this? And I do want to show you his second report, which is actually in the same bundle, if you still have that bundle. Because 2 points, just to foreshadow what I'm about to say.
Tab 16 now, yeah?
Yes, my lord. 2 points are completely clear from the second report. First, he makes clear again that his methodology only works on the basis of the industry evidence. And secondly, he makes clear that he has not considered the methodology in the event the industry evidence is rejected. If I can just show you references. First of all, paragraph 2.6, please. 2.6, my lord. The MNW response was, I should actually point out the heading, factual basis underpinning the assumptions upon which my proposed methodology is reliant. The MNW respondents and KK allege there's an issue with my proposed methodology because I assume pass on from the OEMs to the end customer. As I explained further below, I reject the description. However, it is accurate to say that my methodology relies on certain factual propositions for its robustness. For ease of reference, I set out below the assumptions and the factual basis for these assumptions. And one can see there, in the footnotes, that the footnotes make clear that the factual propositions all derive from the industry report. And then if one looks at 2.8, as the above shows, the assumptions I rely upon are almost entirely based on the evidence of the industry experts regarding how the automotive industry operates. I'm instructed by Scott and Scott these factual propositions will all four be tested at trial if the proposed claim is certified. If other evidence is submitted by any party during the course of the proceedings which casts doubt on the propositions, then I will, of course, consider how this may alter my analysis. So in other words, he's not looked at any of he's not looked at the methodology in the event that the industry evidence is rejected. That's notwithstanding that we had made clear that we would contest the evidence at trial. And then if one moves to 4.14, sorry, if I start at 4.3, page 424 of the bundle. So the heading is pass on of overcharge through the supply chain. And he says, the second sentence, I consider that my methodology, which relies on the industry experts' evidence as to how in practice the market operates, will arrive at a reasonable estimate. 4.4, there will inevitably be instances of which the respondents have raised certain hypothetical examples whereby the normal processes in the market may not hold. However, based on the industry experts' evidence, these will be outliers and in a small minority. And then at 4.5, as I've explained above, the evidence given by the industry experts is to the effect that passing the cost onto the end customer is accepted as industry standard. I have relied on that evidence in formulating my proposed methodology. And then if I could ask you to turn to 4.14.
What do you say at this stage he should have done?
Well, at this stage, my lord, we say that they needed to come up with a methodology which was not entirely contingent upon their industry evidence. So where we have made clear that the industry evidence is not accepted, and that when we proceed, or if the case proceeds to trial, we will be taking issue with the industry evidence, then we say at this stage, it is incumbent on the proposed class representative to prove to the tribunal that they will have a methodology capable of calculating the loss at trial in the event that we succeed on the facts. And my lord, it's really, that's the nub of it.
Well, what do you mean by if you succeed on the facts?
Well,
if you succeed completely, i.e. car prices didn't change because of the cartel, then there's no loss. And if you succeed partially, then what?
Well, my lord, if there's, well, we may succeed because there's no overcharge. We may succeed because customers are shown not to have paid higher prices for their vehicles. But there is a much more nuanced third possibility, which is there may have been an overcharge, there may have been a degree of pass-on, and then there needs to be a methodology which is capable of measuring the extent of pass-on. I keep referring to it as pass-on, but it's measuring loss. How much loss did this class actually suffer? And one needs to be able to have a methodology to measure that. It's not simply, well, our industry evidence is it was always passed on throughout the whole period by every single operator in this chain. And on that basis, the quantum of the loss is as follows. It's actually, here's a methodology, a model that is capable of measuring that. And I do stress that what he's doing at part 2 is quite different to part 1, which is a conventional regression model. Let's look at prices, what happened to shipping overcharges during the cartel period and compare them to the clean period after. That's a model, that's an economic model to work out whether in fact there was an overcharge. Whereas once he moves to part 2, it's simply saying, well, on these facts, the loss is X. And we say that's not acceptable because if we move forward to trial and it turns out at trial that the industry evidence is materially undermined by the defendants, then the trial judge will not have a methodology from the class representative that is capable of adapting to that scenario.
In paragraph 2.8, he says that if he gets further evidence, he will, quote, of course, consider how this may alter my analysis. I suppose what he's saying is he doesn't accept that Mr. Cunningham nor Mr. Dent actually provide sufficient evidence at this point for him to revisit his methodology.
Well, he does say that. He does say that I have not considered a scenario in which the industry evidence is held not to be correct. He does say that. And there's numerous places. There's some more references which I'll come to. He makes absolutely plain that he's only doing this on the basis of the industry evidence. And
but he hasn't seen your industry evidence yet. With respect to Mr. Dent and Mr. Cunningham, their evidence, they're not backed up by documents or empirical analysis. They may be in due course, it's not a criticism. But maybe all he's saying is, once I actually see the evidence, I will, of course, go back and revisit my methodology.
Well, we say that's not acceptable, because we say that they have the burden of proof in relation to the process test. The process test applies at the certification stage. It's effectively a one-off opportunity at the initial stage for the tribunal to assess what has been put forward. And if what has been put forward is not capable of adaptation, and I'll take your lordship to
So what do you mean one-off?
The certification stage, my lord, once a case has been certified, I think there are references in the Supreme Court's decision in Merrick to perhaps certification being looked at or revisited again. Yeah. But it's a one-off in the sense of it's the first stage of the process at which the court looks at the case and decides.
It's not cast in stone.
It's not cast in stone, but we say at that initial stage, it's not good enough for them to turn up with a particular set of facts. And
Is there a requirement on your side to put your cards on the table or serve your evidence or plead before certification?
There's no requirement, but the burden of proof is very much on the class representative to satisfy the process test. And we say the process test requires the class representative to satisfy the tribunal, not merely that the methodology works on the basis of its own evidence, but also that it has a realistic prospect of succeeding or working at trial. And you know, one sees in the Supreme Court Lord Sales and Lord Leggett saying the reason we have a gatekeeper role is to avoid high-value litigation being certified only to run into the sand, to use their words, at a later date. And we say at this stage, where the proposed class representative is on notice that the industry evidence is not going to be accepted, then it is incumbent on them, if they want to satisfy the process test, to say, well, we've seen what the case is going to be against us at trial. In that event, we will do X, Y, Z. And actually in Gutmann, for example, which we will look at in due course, the tribunal there was satisfied that Mr. Holt had put forward a detailed and sophisticated methodology which was sensitive. There was questioning of Mr. Holt at the first instance stage. And it was a different case for reasons which I'll come on to. But we say that that is the process that needs to be conducted by the tribunal. It's not simply rubber stamping and saying, well, we see there's industry evidence. It hasn't obviously been undermined, to pick up the tribunal's language from their judgment, and therefore we certify.
So you're saying there's no basis in fact for the commonality requirement because of what you put in your evidence? Is that the point?
My Lord, your Lordship is, I think, putting to me the wording of Justice Rothstein in the process case 118. We say the process test requires a methodology which has a realistic prospect of working or succeeding at trial. And that means that it's not good enough to say, well, if we are right as to the facts, then the methodology works. There needs to, the tribunal needs to be satisfied that there is a realistic prospect of the methodology working at trial, and that includes, to pick up Lord Justice Green's dictum, that includes if the defendants succeed on certain issues. So in the Gutmann case, for example, my Lord, the defendants were taking points such as, well, there may be a certain category of customers who didn't in fact suffer loss. And the tribunal and the Court of Appeal held, well, that's easy to deal with at a later stage because you just carve out those customers. And we say this is a rather different case where a fundamentally different methodology would need to be devised. Because if one is looking at whether this overcharge at stage one actually moves all the way down to the end customers, the tribunal, we say, under process, should require the class representative to put forward a methodology that actually goes about calculating that or measuring that, as opposed to saying, well, we've got this industry evidence, which says 100% pass on throughout the period by all operators, and then the quantum number is as follows. It's not an econometric model, which is actually ascertaining or measuring the extent of loss. And that's what we say is actually fundamentally defective about this expert methodology. It's not really a methodology at all. It's simply Mr. Robinson calculating the loss on the footing that there was always 100% pass on. Can I just finish? I think your Lordships have the point, but just to give you the references, I think I was showing you, 414, I think I was, is another place where he says, I accept that if during the course of the proceedings the respondents will introduce evidence which contradicts the assumptions put forward by the claimant's industry experts on which my analysis is based, I would consider how this may change my approach. And at 433, it says, I've constructed a methodology which reflects the characteristics of the market and the behaviour of the vehicle companies by reference to the experience and knowledge of industry experts. My methodology, therefore, works within the constraints of certain supplied assumptions. And then the final sentence of this paragraph, the penultimate sentence actually, it's likely that the impact of this would be a high level of damage to the end customer compared to a scenario where the industry expert's assertion holds. Should robust evidence become available, which would lead to a relaxation of my assumption, my methodology could be adapted in due course. And then if one moves to the conclusion, a summary of conclusions at 7.3 on page 453. My methodology with respect to the pass-on of the overcharge through the supply chain relies on certain factual propositions for its robustness, and these are almost entirely based upon the evidence of the industry experts. I consider it important that any approach reflects the market practices which the industry experts have outlined. And then at 7.9, or 7.8, we can pick up 7.8 over the page. Second sentence, I consider that my methodology, which relies on the industry experts' evidence as to how in practice the market operates, will arrive at a reasonable estimate. And then 7.9, I accept that if during the course of proceedings the respondents were to introduce evidence which contradicts the assumptions put forward by the claimant's industry experts, I would consider how this may change my approach. So, my Lords, as I said, two things are abundantly clear. One, what he's doing is entirely premised on the industry evidence. And two, he has not yet considered what he would do in the event that some or all of the industry evidence is rejected. And we say that is something which it is incumbent on the proposed class representative to grapple with at the certification stage. This is not a situation where he's put something forward on a provisional basis but says, well, I need disclosure or I need further data, and therefore this is the best I can do at this stage. They have taken a positive decision to proceed in this way. And therefore, we say this is a methodology which fails the process test. And just to highlight why we say a fundamentally different methodology will be required. So it's not merely making adjustments to what has already been put forward. Again, just working through the three levels of the supply chain. Well, what if some OEMs did not pass on the overcharge to the NSCs? For example, I think I mentioned earlier, some may have been in the same corporate group, some may not have been. So how does one deal with that at stage one? At stage two, what if some national sales companies passed on the overcharge to retailers, but others did not? Was there a difference between some NSCs...
So were these points that were made in your evidence that you just showed us?
My Lord, these points are... I'm actually about to show you a short expert report which we served from RBB, which made good these points.
Because those 2 points you just made weren't made in the evidence you did show us.
No, so the factual evidence was simply two individuals explaining, I'm a buyer from Hertz, this is how we buy vehicles, and I'm a retail dealer at BMW.
At the moment, no criticism of Mr. Robinson for not dealing with the points that you've just made on the basis of the evidence we've seen so far.
Because they, well, my Lord, the criticism of Mr. Robinson is a failure to deal with different facts. So the Cunningham and Dent statements were examples of different facts. So negotiations happening, which are not...
Right, but at a different level than the two.
A different level, exactly, my Lord. But I'm about to show you the RBB report, which goes through the stages in the same way that I'm doing now, where RBB, our expert, says if you're doing this properly and actually measuring the extent of pass-on and loss, then you need to look at it stage by stage. But your Lordship's right about the different stages at which this arises, but I'm just trying to break it down so that there can be no doubt as to how many different permutations there could be. So at stage two, what if some national sales companies passed on the overcharge? What if there was a difference between those who had an itemised delivery charge and those who didn't? What if some of them had a different pricing strategy at different times within the claim period? What if some NSCs sometimes just increased delivery charges because they wanted more margin, which indeed is a commercial decision that even Messrs. Goss and Whitehorn accept could sometimes happen. They just look at what their competitors are doing and increase their prices. What if, as I mentioned, some NSCs want to keep prices competitive with excluded brands? So you've got the whole market here may not be operating in exactly the same way throughout the 6-year claim period. And then moving to the third level of the supply chain, what if some retailers didn't pass the delivery charge on because it was negotiated away? Was there a different practice between those who had an itemised delivery charge and those who didn't? And so there are all sorts of points which arise. And the only adjustment which is mentioned in the BDO report, if I could show you this, because if you still have the second report open, at paragraph 4.57, which is page...
457?
457, yes, my Lord. Now, this is the only example that's given, and it appears in the judgment and also is relied upon by Miss Ford in her skeleton. What he says here is, if it is the case that all car rental companies were able to refuse to pay the delivery charge, this can be easily identified and would not have a material reduction. Now, we say that that is alighting upon a simple example of an adjustment that could be made, which is carving out a particular type of customer. But with respect, it doesn't grapple with the difficulties that arise on the basis of what I've just said, different operators pricing differently at each level of the supply chain at different times. And so if I
from the CAT's point of view, at some stage, let's just ex-hypothesize the action proceeds, we get to the point at which there's been disclosure and witness statements and expert evidence, or about final expert evidence about to be served. The CAT then sends the parties away to identify a list of issues and to inform the CAT as to whether they're significant or insignificant disputes, and how they might be resolved. Is that the sort of thing you expect to be seen in the methodology, or is that something which naturally occurs as a case management matter for the CAT 12 months down the line?
Well,
I understand what you're saying about the permutations. I can see they, we can understand them. But the question is, at what stage does the CAT grapple with them in a realistic and practical sense?
So, my lord, we are not taking an unrealistic stance or a counsel of perfection. We are not saying they need to turn up at the certification stage with a polished methodology, which will be the methodology that will remain the methodology that they use at trial. We're obviously, to a certain degree, things will evolve post-disclosure and so on. But what we do submit is that it's not acceptable at this stage to effectively stick their head in the sand and say, well, this is how we intend to do it. We intend to proceed on the basis the industry evidence is correct. And we may be right about that, we may be wrong about that, but that's a matter for trial. We say that really is not properly taking into account the importance of the gatekeeper role, because the case should only move forward post-certification if the tribunal is satisfied that the methodology is capable of dealing with different scenarios. To use the words of the tribunal in Gutmann, is it sensitive? Is it detailed and is it sophisticated? And we say this is completely unsophisticated, it's completely undetailed, it's not actually a methodology, my lord, that's the real point. It's Mr. Robinson calculating the loss on the back of the industry evidence. It's very...
What's wrong with that? An expert who's asked to give his opinion on something or other will base it on certain facts, usually facts that he or she's been told about by the side who commissioned the report. And if the facts are not found, as the instructions are, then the opinion will have to change. I mean, isn't that commonplace in expert?
Well, my lord, with respect, we're dealing here with an economic methodology.
Well, you say it's calculation. Well, it may well be. It's a calculation based on certain inputs. And if it's a calculation rather than a methodology, one might have thought that it ought to be easier to adapt it to found facts than if it is a methodology, to use your expression.
My lord, can I show you the RBB report? Because the RBB report explains, in very simple terms, the point I've been making, which is one has to actually investigate. If this is to be a methodology for computing or calculating the loss suffered by the class, then it needs to deal with the various permutations that are going to arise. It's not a methodology for calculating pass-on or calculating the loss suffered if it's simply saying, well, we take the industry evidence as read, and on that basis the loss is as follows. That's not actually measuring the extent to which the overcharge may have moved its way from the beginning to the end of the supply chain. But let me show you the RBB report, which is behind tab 12. And this just explains, on a stage-by-stage basis, that if the methodology that's being put forward, it's not just a case of adjusting it or revising the calculations. If one's actually serious about doing this in a proper manner, then one has to break it down. And if one starts on page 351, so we're at the first level of the supply chain, paragraph 11, the proposed methodology does not consider the issue of pass-on, implicitly assuming it's 100%. And at 12 and 13, well, that may be reasonable in some cases, but it may not be. And at paragraph 13, OEMs and NSCs are not always part of the same firm. And then over the page, last sentence, the proposed methodology has not addressed this point, implicitly assuming pass-on to be 100%. And then section 3 is dealing with NSC to dealers. And at paragraph 18, it's important to appreciate from the outset that the proposed methodology does not estimate pass-on. It assumes pass-on to be 100%. And then the final sentence, this cannot reliably capture the extent of any pass-on. And then if one...
This is a fairly abstract opinion.
Yes.
It does cross-refer to your witness statements on a couple of occasions. But it's largely at the level of theory. Are you saying that this is the sort of report that should have caused somebody who has based an expert opinion on facts to alter that? This isn't based upon facts. This is expert opinion in the abstract?
This is
overwhelming, not entirely.
No, absolutely. This is largely abstract. It's saying if one is trying to come up with a methodology for actually working out the extent to which any shipping overcharge made its way from the OEMs down to the end customers, these are the sorts of points that one needs to grapple with, rather than jumping straight to...
That I understand.
Exactly. So it is in the abstract, because it's obviously not for us to put forward a methodology.
No.
We're simply saying this is what they've done, which is piggyback entirely on the industry evidence. This is what an economic methodology ought to look like. You need to build it up. You need to take it stage by stage, 3 stages of the supply chain. Was it really 100% from OEMs to NSCs? As between NSCs and retailers, you need to look at the following matters.
I understand that. Isn't the difficulty here that the CAT simply found that at the certification stage, it preferred the classes analysis over yours? It's not saying that you won't win a trial once more evidence has come forward, but at the stage, they just simply preferred A over B.
Well, I'll come to the CAT's judgment. What the CAT says is, we've seen the industry evidence which was not obviously undermined by the respondents. Now, we say that that is an error of law, because what they've done there is essentially say, well, this is not a mini-trial, we can't decide any facts. The industry evidence may or may not be right, we'll see at trial, but we'll certify. And we say, no, that's not the process test. The process test means that the methodology needs to be capable of adjustment in the event that the defendants succeed on certain issues. So whilst there is a very important distinction, with respect, my lord, between a summary judgment application and an application of the process test, because I fully accept that we could not succeed on a summary judgment application. That's different to the point Mr. Mitriou is running. Absolutely accept that on the basis of their industry evidence and on the basis of BDO, they're entitled to defeat a summary judgment application by saying, well, we may be right, we may be wrong, but the CAT can't deal with this at this early stage. The process test, we say, is fundamentally different, because what the CAT has to have regard to is how the proceedings will move forward. And as I say, in Merrick's, the concern is to ensure that cases are not certified but then run into the sand. And so what we say is it was incumbent on them not to come up with a final and polished methodology, because we do accept this is an early stage, but what we do submit they ought to be able to do and must do at this stage is the kind of analysis which RBB are suggesting. It is in the abstract, the RBB note, but with respect it makes rather obvious points. That if one is actually inquiring whether or not NSCs passed on the overcharge to retailers, whether or not retailers passed that on to customers, one actually needs to investigate that. And that's what we say, that's the process test, that the methodology actually needs to ascertain the extent of loss, not merely assume that all of the loss
Is that investigation a factual investigation or a matter for expert opinion?
My lord, what would have been acceptable is for the proposed class representative to put forward a methodology, but which was provisional, pending disclosure and witness evidence and so on. But the basic model needed to be one that could deal with those facts. And that's really the vice here, that the methodology is not capable of... Let's assume that NSCs were actually increasing delivery charges simply to make more margin, or let's assume retailers were in fact willing to negotiate down the delivery charge. At that stage, if those are the facts found at trial, then the Mr. Robinson's methodology falls over completely. And so what they needed to do was to put forward a model or a methodology similar to the conventional regression model that is being used at stage 1. And they perfectly well say, this is how we intend to go about it, but of course we need disclosure, of course we need witness evidence. They've actually chosen to go about it in a wrong-headed way, we submit. And so perhaps I don't need to show you all of the paragraphs, but RBB do just go through on a stage-by-stage basis and explain this, that the fundamentally different methodology wouldn't be needed at 35 and 36. Issues and evidence that would need to be considered would include the following for each NSC: how they determined prices, what were the factors determining the prices, how did they determine their delivery charges, how did they change their delivery charges in response to changes in the shipping costs. And so we're not saying they needed to have final answers on each of these points, but they needed to have a model which could genuinely inquire as to these issues. And at 39, we're now looking at the end consumer stage of the analysis. The 38, 39, the PM does not consider this issue other than to assume it's passed on in full. It's unlikely to be valid. Dealers may seek to reduce their own margins. 39, ignoring the prospect of dealers absorbing some of the alleged overcharge is a fundamental gap. Further, the PM cannot be readily adapted to take these omissions into account, since it would require a fresh methodology. And if one looks at 46 and 47, the heading being important issues in establishing a viable methodology for estimating pass-on by dealers to end consumers, undertaking a suitable analysis would require significant further investigation. The proposed methodology would need to be adjusted substantially to incorporate the information sought. Issues and evidence that would need to be considered. So again, this is not they need to have considered them by the certification stage, but they need to have a plan. The expert needs to have a method by which these matters can be investigated. And with respect, they are obvious points. How the dealer determined prices, the factors that determined the prices, how the proposed methodology would incorporate the information sought.
Does your client have disclosure on those matters?
I don't know. Obviously, my client's at the OEMs, at the OEM stage. So disclosure. The shipping, sorry,
You're a shipping company.
No, but the alleged any shipping overcharge would have been incurred by the OEM.
That's what I'm asking. Would you have evidence of this? The sorts of things that Dr. Majumdar is saying would need to be investigated. Would you have evidence to disclose on those matters?
The defendants are obviously operating at the first stage. So it's shipping overcharge, if there was one, would have gone to the OEM. So your Lordship's absolutely right. We're not.
But you may not have that evidence, which you're saying is essential.
No, I understand. So your Lordship's saying, well, they may not get better disclosure in relation to these matters from the defendant.
They may not get any from you.
They may not get any, but
you may have evidence. I imagine there could well be disclosure relevant to what your ability, elasticity of demand at those immediately below you and how easy they can pass on costs. There may be some of that, but as to the actual negotiating
No, I understand. So your Lordship is putting to me the proposition that, of course, that we are not going to be able to give them disclosure.
And you're saying that they can't because they're the downstream purchasers.
No, I understand.
You're saying that they can't succeed unless they.
But the problem is,
with this evidence.
with respect, my Lord, what is striking about Mr. Robinson's evidence is he is not saying that he is going about this in this way for data reasons. So this is not, I am limited by the disclosure that I will receive, that there are data issues, and therefore this is the methodology I'm going to use.
Yeah.
That is not this case. That is the case in many other collective proceedings, as your Lordship knows. But what is striking is they have chosen to adopt this method, and it's not for data reasons. Nowhere does one see. There are references to this being provisional, and so on and so forth, but actually those are all in relation to stage one, which is the overcharge. There's only one reference to data issues, but that's all about at the top end of the supply chain. There is no point taken that they've chosen to adopt this method because of data issues. So at part two, which is measuring the extent of pass-on, they've gone down this road of saying we're going to work entirely on the back of the industry evidence.
Yeah, no, we've got that point. I think we need to move on a bit now, Mr. Singler.
Yes, my Lord. Can I quickly take you through the Gutmann decision?
Yes.
Because we do say paragraph 56 in particular is important. If we pick it up at 52, which is my Lord Justice Green's observations on the Microsoft test, it's tab 26 of Authorities 3. So the Lordships have that. Page 872 of the bundle. So 53, it's not a statutory test, there's no magic to it, articulates a common sense approach. 54, the test is counterfactual. The methodology is based on a counterfactual model of how the market would have operated absent abuse. It's quintessentially hypothetical. And for this reason, we'll use assumptions and models and frequently regression analysis. And we note that reference to models and regression, because as I say, there's no such thing that's being carried out here. 55, absence of disclosure. This is the point we've just touched on. The methodology is subject to disclosure, necessarily provisional. And as to this, we say that may be the case in other proceedings, but here this is not a data point. It's a fundamental failure to adopt the right sort of methodology. So the problems that we've identified will not be fixed by disclosure. They need to grapple with different facts. Now, 56 we submit is very important. At the certification stage, the methodology must identify the issues, not the answers. CAT's concerned to identify the issues and gauge whether the methodology proposed is workable at trial when the issues are tested and might lead to different answers, some in favour of defendants. Because of this, the CAT will wish to assess whether, if the defendants do win on some issues at trial, the methodology is capable of being adjusted so as to reflect any partial victory by the class. Now, we say this is exactly our point. If we succeed in undermining material parts of the industry evidence, the methodology is not capable of being adjusted. Now, there are references at 58 and 60 to the court being able to wield the broad axe at trial. And so...
well, and I'm just looking at 58 reminding myself what was said. I mean, I think that there's two things we were concentrating on. The broad axe could apply at the certification stage to regulate the amount of data required at that point. And I think it struck us in Goodman that they actually had a lot of data and it was relatively straightforward. But that was an immediate, there was no pass-on issue there. As you go down the chain, claimants' availability, access to data is going to get less.
Yes, so my lord, the first point is the answer I've already given, which is the justification is not lack of data for why they're going about this in this way. That's never been their case. So that's the first point. This is not a case where they're saying this is the best we can do given limitations on data. They've chosen to calculate pass-on in this manner. The second point is actually Gutman was a very different case because in Gutman, as your lordship knows, the issue was did these customers overpay for their train tickets? Now, one knows or one can find out what the price of the train ticket was. So the issue there was actually working out which customers suffered that loss. Here, it's a rather different case. We are trying to work out what the loss was. And so we say that our case throws up a whole number of factual issues.
No, absolutely. Every case is going to be very different.
Exactly, and in Gutman, the points being taken by the respondents on appeal was that Mr. Holt had not yet conducted his survey. Well, that's, with respect, obviously, that he doesn't need to finish off all of his work by the certification stage. And the other point taken was the CAT made an assumption that people would have bought these cheaper tickets if they were available. Well, with respect, that was a common sense assumption for the CAT to make. So one can see in that case, the Court of Appeal readily held.
Understood. It was an easier case on the facts.
Exactly, my lord. And we just say that the methodology here just doesn't begin to grapple with all of the questions that will arise at trial. The broad axe will not help here because it's not simply carving out certain customers who didn't suffer loss. It's actually, there could be a whole host of different rates of pass-on at different levels and indeed at different times. And then we do also rely on 61. I think Mr. Dimitri showed you that the Microsoft test is not toothless, and there's an important gatekeeper role. And we do say that the problem here is that the methodology will run into the sand, and the certification stage is the stage at which the CAT should grapple with this. And at 67, one can see the difference between this case and the Gutman case, because the CAT there was at pains to satisfy itself during the certification hearing that the methodology could be adapted so as to reflect, for instance, issues upon which the defendants might be successful. Now, we say the same principle applies here, and the methodology falls over entirely if we succeed on certain issues. Can I look now at the tribunal's judgment, the relevant paragraphs, where we say they fell into error? It's the core bundle of tab 11. One starts at paragraph 103, which is bundle page 171. Your Lordships will see the final sentence of 103, that the submission that we were making, the methodology would not be capable of dealing with material exceptions, and therefore was not sufficiently plausible. So that's the submission. 104, final sentence. The criticisms of the proposed methodology go too far. 105, we've made the point there's no rule that confines the concept of methodology to a particular econometric technique. Well, with respect, that's a false point, because we weren't objecting to the use of qualitative evidence in conjunction with Mr. Robinson's report. What we were saying was this is highly unusual, because the expert is not, there's no economic evidence or model to work out what the extent of pass-on was. At 105 and 106 and 110, are important paragraphs. What they say, the tribunal, in those paragraphs, is one can see midway through 105, it's not our role to determine the merits of the case at this stage. 106, ultimately, if the expert evidence can be successfully challenged at trial, the claim may fail. But the test is not so onerous that we should reject any methodology that may break down in the face of a challenge to evidence. And 110, we've scrutinised the methodology. The applicant's industry experts have a great deal of experience. The evidence is clear that any overcharge would have been passed on. We would not characterise those as extreme factual assumptions. In principle, they're plausible. While some evidence about practice has been adduced on behalf of KK, we've seen nothing that obviously undermines key elements of the applicant's evidence. We specifically reject the submission that points of difference between the witnesses means that the applicant's methodology cannot be grounded in the facts as the test requires. It is not our role at this stage to find the facts beyond determining whether the threshold just referred to is met. Now, my lords, we do submit that this was a misapplication of the process test and an error of law because we were not asking the tribunal to find any facts. With respect, they missed the point of why we served the evidence that we did. We were simply showing the tribunal that there would be a major factual dispute at trial, and we were submitting that the process test needs a methodology capable of adapting to different facts. And therefore, it's no good answer we submit to say, well, the evidence is plausible, and therefore the case should proceed to trial. That's not the process test. And then at 111, second sentence, at this stage we also have no basis to conclude that it would not be feasible for any successful evidential challenge to the quantum of loss claim to be addressed, whether by adjusting the methodology or making some other adjustment to the quantum. Now, we make 2 points about this, my lords. First, we say the tribunal fell into error because it reversed the burden of proof. So no basis to conclude that it would not be feasible, we say, is a reversal of the burden of proof. But secondly, and more fundamentally, we say the tribunal had no basis to conclude that the methodology could be adapted to different facts. I've already shown you that Mr. Robinson quite fairly says in his reports he's not yet come up with a methodology to deal with different facts. He says he'll do that in due course. And so we say the tribunal had no basis to proceed on the assumption that this methodology could be adjusted. In fact, when one considers the question properly, the methodology can't simply be adjusted. It's a fundamentally different methodology that would be required if we were to succeed on the facts at trial. And a continuation of the same errors that I've alluded to at 113, the final sentence after dealing with the merits judgment. Here, there is evidence from industry experts, key elements of which have not been obviously undermined. And we say, well, we were not asking the tribunal to find the facts. We're simply saying that they had to have regard to what would happen if the facts turned out to be different to the industry evidence at trial. Can I now finally deal with the skeleton argument of the class representative to show you how they seek to defend that reasoning, which we say doesn't stand up to the test as it has been explained in the Gutman case. The skeleton is in tab 7, the core bundle. If I can pick this up at paragraphs 2 and 3, page 91 of the bundle. Lordships have paragraph 2. The respondent's position is that the appeals are fundamentally misconceived. They both mischaracterise the conclusions and seek to embroil the court in factual disputes that are inherently unsuitable, can only be resolved at trial, etc. And then the final sentence, KK invites this court to conclude that the expert industry evidence comprises nothing more than a series of extreme and highly prescriptive factual assumptions. These barely concealed attempts to inveigle this court into highly contested factual disputes should be given short shrift. Well, with respect, we say that's completely wrong. We weren't asking the CAT to determine any findings of fact. We certainly aren't asking this tribunal, the Court of Appeal, to get into that.
Well, you agree, I'm sure, that you can only appeal on a question of law.
Yes.
And 2 points I can see that you have identified are firstly that in deciding the question of feasibility, the CAT wrongly reversed the burden of proof. And the second is that it was an error of law for the CAT not to have considered how the methodology could be adapted in the event that your clients, or Mr. Dimitri's clients won on some or all of the facts to be contested.
I'm grateful.
Have I identified?
Absolutely right. Yes, my lord. So that's exactly it. And I can take the rest of the discussion very shortly because that really is the nub of it. The 2 points are developed. Paragraphs, if one just picks up 47 and 48 first, my lords, which is page 108 of the bundle. Yeah. You'll see KK's argument at 47, and then at 48, 2 overarching points. The premise is false, because we seek to mischaracterise the industry expert's evidence. Our appeal cannot get off the ground, they say. And then the second point is misapprehends the nature of the conclusion. Didn't find that the test was satisfied only on the premise that the evidence would be entirely correct. On the contrary, the tribunal was conscious of the possibility that the respondent might enjoy partial success at trial. And then those points are developed. The first one is developed at 50 to 55. And you'll see at 52, they say we have a fundamental difficulty because our entire appeal rests on our description of the industry evidence as highly prescriptive. And we say that's actually completely wrong. It's the same error that was made by the tribunal. It's not a question of whether the industry evidence was plausible or extreme. It's just whether it could be, the methodology of BDO could be adapted to different facts. So at 55, they say, well, you haven't purported to challenge the assessment of the evidence, and therefore your appeals focus on a logically subsequent question. We say they've completely missed the point that we were making below and are making now. So there's a pure question of law about what the process test requires. And it requires adaptation to different facts. And then the second point they make is developed at paragraph 59 of the skeleton, where they say the respondent did contend in the proceedings below that its proposed methodology could accommodate different factual findings to those advanced by the industry experts. And it's evident from the judgment that the tribunal anticipated a world in which the respondent could succeed, at least in part, even if some aspects of the industry expert evidence was disproved at trial. And then you'll see in the final sentence, for the reasons explained at 43 to 45 above, this finding on the part of the tribunal had a sound evidential basis and is consistent with principle. Now, importantly, my lords, 43 to 45 above deal with the adjustment that is the one at paragraph 457 of the second BDO report. It's the exclusion of rental companies. So that's a very straightforward example where you can simply carve out one category of customer. We say they focused on one very small, easy example, but they've missed the bigger picture. Footnote 6 of the skeleton, they give a further example where you can carve out certain vehicle brands. Again, we say this is missing the bigger point, that the methodology is not investigating the extent of pass-on. So this is unlike Gutmann, where you're simply carving out some people who didn't suffer any loss. This is actually not going about the process in the right way at all. So, my lords, we do submit that the tribunal was wrong to hold that the process test was satisfied. And just finally, what's surprising about the submission at 59 is that below, Ms. Ford did not seek to argue that the tribunal should certify, taking into account the possibility of adjustments that might be made in the future. On the contrary, she accepted expressly, both in opening and in reply, that the methodology as it currently stands has to satisfy the process test. And we've included, I won't, for time reasons, take you to the transcript extracts, but they're in the bundle. The first is day 1, at pages 119 to 122, which is supplemental bundle 2, tab 18. And the second is day 3, page 139, which is supplemental 2, tab 19. And we say she was quite correct to concede that all the tribunal can apply the process test to is the methodology that has been put forward at this stage. But that then creates a fundamental problem, because applying the test as it's been explained in Gutmann, the test means that they need to show a methodology that can adapt to different facts. Because they've not done that at this stage, we submit the process test was failed. So, my lords, unless I can assist any further, those are my submissions.
Thank you very much. Yes, Ms. Ford.
My lords, in terms of the structure of my submissions, they're in 4 parts. First, I propose to give a brief reminder of what the court said concerning methodology and appeals against certification in both Gutmann and in Le Paterel. Secondly, I would like to show the court the key paragraphs of our expert reports where our methodology is set out. Thirdly, I'll address the MNW Appellants appeal, including our respondent's notice point on fault in shipping. and fourthly I'll come to address K-Line's appeal. Starting with the key principles, the court has already been taken to some of the guidance that this court gave in Gutmann. It's Authorities Bundle tab 26. And in our submission, what one gets from this, fundamentally, is that there is no requirement on the class representative to anticipate and preemptively address, at the CPO stage, the case the respondents may in due course run at trial. Starting at paragraph 44 on page 869, the court has summarised the fundamental role of the methodology.
Sorry, I missed the paragraph.
I'm sorry, it's paragraph 44 on page
54?
44.
44.
Halfway through this paragraph, we see the court saying the methodology acts as a broad blueprint identifying the issues for trial and how they are to be resolved, and provides important material from which the CAT can determine whether the issues are common and suitable for certification. In our submission, some of the submissions that have been made in particular this afternoon about the content of the process test lose sight of this explanation as to the role of the methodology. Beginning at 45, the court then sets out the Microsoft test. It's worth noting that the actual facts in the Microsoft case were concerned with an overcharge which it was alleged to be suffered by electronics manufacturers, and then it was said that that overcharge had been passed down the chain of distribution to class members. So the Microsoft case was grappling with similar issues to those which arise in this case. We can see that from the summary at paragraph 45. And it's in that context, when we come to paragraph 46, that the test set out by the Canadian Supreme Court, which has been endorsed as the applicable test in this jurisdiction, is set out, and it's not, we know from Merrick's, an onerous one.
Just to transpose the quotation from Justice Rothstein to this case, the expert methodology is not simply Mr. Robinson, it's Mr. Robinson plus the industry experts.
Your Lordship is quite right, and I will come on to show Your Lordship that that's an observation the CAT made, and it was in response to submissions that in particular Mr. Singler made below, which have been echoed this afternoon.
Yeah. So when we're looking for some basis in fact, you are entitled to say, well, we've got that basis in fact, it's in the Goss report.
My Lord, yes, we're entitled to say that our methodology as a whole is to be assessed against this test, not simply Mr. Robinson's methodology, and it's an inappropriate criticism to say that because Mr. Robinson is not performing an econometric analysis, that his methodology is in some way lacking. The wording of the test is set out in 46, and it's worth emphasising the sort of terminology one sees here, and the court actually goes on to make this point later in the judgment. But it's a sufficiently credible or plausible methodology to establish some basis in fact for the commonality requirement. This means that the methodology must offer a realistic prospect of establishing loss on a class-wide basis, so that if the overcharge is eventually established at the trial of the common issues, there is a means by which to demonstrate that it is common to the class. Methodology cannot be purely theoretical or hypothetical, but must be grounded in the facts of the particular case in question, and there must be some evidence of the availability of the data to which the methodology is to be applied. So that is the test that we are applying to our methodology. And the court then makes some observations on that from paragraph 52 onwards. And you've been shown some of these. 53, the Microsoft test is not a statutory test, there's no magic to it. It articulates a common sense approach that any court should be able to apply. Importantly, it confers upon the court or tribunal a broad discretion to approve of the methodology to be used at trial. And this is the passage where the court goes on to emphasise the nature of the terminology, the terms used in the test, as I have done. And the conclusion that's drawn at the end of this paragraph is those terms highlight both the discretion conferred upon the CAT to make a value judgment, but also the relative nature of the exercise. We then see 54, the test is counterfactual. 55, the methodology is subject to a certification assessment prior to disclosure and is thereby necessarily provisional and might properly identify refinements of further work to be carried out after disclosure. One sees partway down this paragraph, at the certification stage, all that might be possible is for the class representative to advance a methodology identifying what might be done following disclosure. And this, in my submission, is one of the first of a number of passages where the court is contemplating that this is an ongoing process between the point of certification and trial. And that, in my submission, is in contrast to the submissions made by Mr. Singler just now, that essentially the class rep's methodology is obliged to try and anticipate and deal now with the nature of the respondent's case that they may run at trial. We will see as we work through that this is a process which takes place later and it points up to and including trial.
If just going back to the test itself or its formulation in paragraph 46, when it's talking about something that's sufficiently credible or plausible and also making the point that it's a methodology for use at trial, do you say that the claimants are entitled effectively to ignore or disregard points of which they are aware that defendants are going to raise, which will form issues in the conventional sense and which will need to be resolved at trial? I mean, you're not saying that because this all happens at an early stage, you can just say, look, we'll get to you later. This is what we think. I mean, isn't it inherent in this that if it's something to be used at trial, if you know that there's going to be an issue in the conventional sense, i.e. a point of dispute, that the methodology should attempt to deal with it?
My Lord, I do say that what is required is that the class representative sets out their positive case as to their methodology. And where we differ from the respondents to this appeal is that their criticisms in some respects boil down to our failure to set out and address their case that they want to run at trial. And that, in my submission, is not a legitimate criticism of our approach.
Well, I know that's the point, because that's what I'm trying to put to you. It's the question of whether you say, well, we can satisfy the requirement that something that is sufficiently credible or plausible, because we say, with blinkers on, ignore them, it's sufficiently credible or plausible if we're right. They say you can't do that if there's something which is obvious that we're going to raise. You can no longer say that it's sufficiently credible or plausible just on your own view of the world. I mean, the issue I've got here is that, I mean, obviously there is the discussion about that it takes place in the absence of disclosure, but does it take place in the absence of knowledge as to what defences are going to be raised?
Well, my Lord, one does have to take into account that this is an early stage, and I do rely on that point. When one says we have knowledge of what's going to be raised, there hasn't even been a pleaded defence yet. We've had a response to the CPO, and we've had what have been candidly described as some very basic, essentially introductory witness statements. So one must first of all bear in mind that the extent of the information that the class representative has as to the case they're going to face at trial is relatively limited. That's the first point. My Lord, the second point is it is legitimate for the class representative to address that by saying, we see the point you make, but that is a dispute of fact for trial. That is, at this stage, a perfectly legitimate response. And that is...
But I think it goes further than that. They say that your methodology can't even cope with the issue that they want to raise at trial.
My Lord, that's what they say. We do not accept that that is a fair characterisation of our methodology at all. We say that it's perfectly capable of as indeed the tribunal recognised, the effect of the outcome of the CPO process is that issues have been identified. And the tribunal has said, we recognise that this issue has come up. It's a question of fact for trial. You may be successful in your factual evidence that you rely on to say that this is the position, and they may adduce evidence to the contrary. That may or may not work. But the tribunal deals with it in two ways. First, it says the Microsoft test isn't so onerous as to require you to put forward a methodology that is guaranteed to succeed at trial. And I'll show your lordship that passage. But that is important in my submission, because in some respects, the submissions that your lordship has heard come close to saying you have to essentially guarantee success at trial, not just join issue with us on these propositions. Secondly, the way in which the tribunal says it can be addressed, and that's consistent with what the court says in Gutmann, is if the methodology is sufficiently flexible to be able to be adapted to address what the defendants say. And in our submission, all the passages in Mr. Robinson's report that Mr. Singler showed you indicate that Mr. Robinson is saying, yes, I can adapt my methodology.
Well, he actually just says, I'll think about it in due course. He doesn't actually say, I can adapt my methodology. He doesn't say, I've thought about it now and I can say my methodology is adaptable. He just says, as and when I'll think about it.
Well, my lord, certainly the tribunal makes a finding that it is satisfied that it is capable of being adapted sufficiently, and I can show your lordship that. But where we differ, or one of the instances where we differ from the characterisation of the test, is that we say it's not necessary for Mr. Robinson to positively adapt his methodology now in anticipation, and nor is it practical or possible to expect him to do so, again, at this very early stage. It is sufficient in my submission that it is clear the methodology is capable of being adapted to reflect matters as they evolve during the course of proceedings.
Whether it's capable of being adapted, I would have thought it's a question of fact for the tribunal.
My lord, yes.
Whether the tribunal were required to consider how it would be adapted may or may not be a question of law.
If we look at, I'm going to come on to show your lordship what was said in Le Paturel about what is a question of law and what isn't. And in particular, high-level questions of approach have been characterised by the court as capable of being an error of law, but our submission on the facts of this case will be there is no high-level error of approach.
To come to the crux of it, maybe, taking Mr. Demetrius' point about the global price as opposed to, if you like, your severed approach to price. Mr. Demetrius says that your approach misses a fundamental principle of tort, which is you simply ask whether there had been any difference in price in a counterfactual. And then in paragraph 70 of your pleading, Mr. Robinson's report, he simply says Fulton. Well, that's a response, Fulton. Is that a question of law? And if it's not been addressed since it was alive at the hearing, should it have been?
My lord, in my submission, the tribunal was quite right in the way it analysed that. Whether or not there is, but the question of what is the correct measure of loss, is it, do you look at the delivery charge or do you look at the entire price of the car, is fundamentally in dispute between us.
Yep.
And it is a fundamentally factually sensitive dispute, and it is one that the CAT recognised as such and rightly indicated had to be for trial. It could not possibly make a decision as to that issue at this stage in the absence of any evidence from the respondents themselves.
Well, perhaps that's, I think, the only point of relevance you make, which is they can't take a decision in the absence of evidence from the defendants. And the question is, should the methodology, since this was a live issue and pretty fundamental, should the methodology have grappled with it at that point in time? I mean, let's assume, without deciding it at the moment, that it's a point of law, because it really is, what is the fundamental characterisation of damages in a case of tort, in a tort case? So if we treat it as a question of law, it's live. Let's assume, again, for the sake of argument, you lose on Fulton. So you crystallise the argument. Then should, at the certification stage, methodology grapple with what is an absolutely fundamental issue of law at the certification stage?
My lord, in my submission, it clearly has, because we grapple with it by adducing the expert industry evidence indicating that there is a separate charge that is itemised at each individual level of the distribution chain, and that the overwhelming industry standard practice is that that charge is not negotiated away. It's treated as a cost and it's not available for negotiation. So the way in which we have recognised and engaged with that issue that has been raised by the respondents is to say, in our submission, on the basis of our evidence, that is not the correct analysis. You don't look at the overall price of the car, you look at this individual siloed charge. And the tribunal rightly recognised that is a question of fact at trial. It couldn't decide against us now. It is not the case in my submission that there's been any failure to grapple with that at all. The way in which we have grappled with it is to adduce industry expert evidence that this is different from any of the examples that Mr. Mitriou gave in submission, for example, the bottle of wine. The bottle of wine doesn't have a separate itemised charge. It's not supported by evidence that that particular charge isn't commonly negotiated away because of the industry practices. In my submission, those facts that we rely on are sufficient to grapple with this issue that's been raised, and so it's not possible to decide that against us at this stage.
I think your evidence is that the delivery charge is not always separately itemised, that some cars are sold at an all-inclusive on-the-road price.
My lord, I would like to come on to show you exactly what we do say, because of course a lot's been said about what we do and don't say, and I think it may help simply to show you from the industry expert.
But if you're wrong, and whether it's on the law or the facts, and you do look at the overall price of the car, let us suppose, I think what my lord is asking is, does your methodology enable you to deal with that? You say it does.
My lord, in my submission, it is not right to criticise the methodology for not grappling with that. It's not, in my submission, the correct test to require us to plead a case on the terms, essentially, that the respondents want to put. The criticism that's been put against us approaches saying, well, you've pleaded the wrong case. And the criticism is not that we haven't pleaded our case, because we have. It's that you have not pleaded the case that the respondents, the way they characterise the world, the way they see it, you haven't pleaded and addressed that case.
Well, that's certainly what Mr. Mitriou has been telling us all morning.
My lord, indeed, and in our submission, that is not the correct approach to the test. In our submission, it can't be the case that a proposed class rep is obliged to advance a methodology which is designed around and geared towards the respondent's case.
But I'm not sure, with respect to the point my lord's just been putting to you, I'm not sure it does depend upon the respondent's case. You accept that, so your class includes people which I think you accept, some of whom will have been faced with a bill, an invoice which includes a delivery charge itemised, as to which your evidence, or the expert evidence is, they would almost never seek to negotiate away that itemised, that line item, as a separate line item, 4 or 6 times a year or something, whatever it is, very rare. But you also try to put into your class, on the basis that it's a common issue, people who were faced with simply an on-the-road price. And I think the point that's just been put to you is that your methodology deals with the first category by saying the expert evidence is nobody ever tried to negotiate away that specifically identified line. It just doesn't deal with what happens where there's not a specifically identified line, but there is a negotiation about the price, and therefore the methodology just, I think it said, just doesn't deal with it. And that's not relying on anything the respondents are saying, that's actually just looking at your own evidence and your own.
Well, my lord, I will come on to show you that the methodology does deal with it, because it expressly recognises that there are scenarios where there isn't an itemised charge at the retail stage, although they say that this is a charge which has been passed down and itemised at each of the stages.
Yeah, I'm assuming it's passed down to
so we've had an itemised charge. They say in the majority of cases you do have the itemised charge at the retailer stage. They recognise that there are scenarios where you don't, and they say that because this is a hard cost to the retailer, which it's not in the way of a margin that's then available for negotiation, it's a hard cost to them, that the industry standard is they will seek to recover, notwithstanding that in that particular instance they haven't specifically identified it. The same principles apply.
But it doesn't say that there won't be a negotiation down of the on-the-road price, which includes the element of the delivery.
My lord, in my submission, it does say that the delivery charge, whether separately itemised or not, is not negotiated down. I don't want to put it too highly to say never, but I want to show you the exact wording. Okay. They do say that it is the nature of this charge, that because it is a concrete cost to these retailers, there is no reason for them to allow it to be negotiated down. And that is the factual basis on which we say that we are entitled to focus on that element of the cost, in contrast to what might be the more classic approach of saying, okay, well, let's look at the car as a whole. So that your lordships canvassed in submissions the situation with seatbelts. And surely if you had a cartel in seatbelts, you wouldn't be looking at the cost of a seatbelt, you'd be looking at the car as a whole. That, in my submission, is a fact-specific question. And in order to determine what it is that you look at, you would need evidence as to whether or not you have a separately itemised charge for seatbelts and or a situation where each level of the supply chain does not negotiate over the cost to them of a seatbelt. Now, I would speculate that it's highly unlikely that a seatbelt would be in that situation. But our industry expert evidence is that the delivery charge is that situation. It is essentially a siloed charge, and we say that is what entitles us to focus on that charge and not to look at the total value of the car.
When you say it's a hard cost, you mean it's a given to your clients? It's nothing. It's a cost over which they have zero control.
It's one which is, yes, passed down from the stage above them. And I'm using the word hard. I think it is actually a word that is used in the industry expert evidence when they comment on retailer margins. And they are, the point they are making, and I can take your lordship to it.
And the counterfactual to that is a soft cost, which may be something which inferentially is capable of being flexed as part of negotiation. Is that right?
For example, a margin. The context of this discussion, I'll show you, lordship, when we get to it. They're talking about retailer margins. The retailer might well be prepared to negotiate away their margin, but insofar as they are being passed down a hard cost, the industry experts' evidence is that that is not something which is up for negotiation. And that's why we say that we have grappled with this point, that it requires, it's a fact-specific point whether we're right about the measure of loss. Do you look at this individual charge, or do you look at the car as a whole? It's fundamentally an issue between us, as your lordship has heard. And in our submission, it's not something that can be decided against us at this stage.
If it were then raised in pleadings in a very concrete, specific way, would Mr. Robinson then consider that it was appropriate to address the what if? What if I'm wrong? How does the CAT then deal with my errors at trial? So, for example, there's no 100% pass on, it's a lower percentage. Would he be expected to deal with it then?
Well, he's certainly indicated fairly repeatedly in his reports, and Mr. Singler took you to quite a few examples where he said, I make no bones about the fact that my opinion is based on the industry expert evidence. And in our submission, that is a virtue, because it's not one of those reports where you're relying on abstract economic principles. He's saying, I am basing this on what I've been told by the industry expert evidence, but I would revisit it if appropriate. And this does feed into another of the submissions that was made by Ms. Demetriou, the suggestion that we're going to get to trial and somehow the tribunal isn't going to have the material to resolve this issue. It's going to be left without any material. What's it going to do? How's it going to grapple with the issues between the parties? In my submission, that's not a realistic characterisation of what's going to happen. As your lordship indicates, there will be a round of pleadings. On the basis of the pleadings, there will then be disclosure, factual and expert evidence. And it will be open to us at that stage to grapple with the case that's being put by the respondents, either by adducing our own factual evidence about the way in which customers negotiate, the way in which list prices are set, all the things, the suppositions that have been advanced in support of this appeal. It will be open to us at that stage to engage with the factual premise of those. It will also be open to us to engage with the expert evidence that's adduced and to test that and to cross-examine them on that. And it will be open to us to address the case by way of legal submission insofar as is appropriate. So it's not at all correct in my submission to imply that because at the CPO stage the class representative has advanced its positive case, how it considers that it establishes it has a real prospect of success here. It's not the case that the tribunal is going to be left unable to resolve the issues at trial.
So, UK, there are two tortious theories of damages here. There's the global theory, whereby in the counterfactual nothing ever changes. You say in the counterfactual nothing ever changes, but the delivery charge being siloed will change.
Insofar
there are two silos. There's everything else, and there's the delivery charge in the counterfactual.
Insofar as, and again we'll come on to see exactly what Mr. Robinson does, but he identifies the extent to which there's been an increase, and he takes the lower of the amount of the overcharge and the increase, and he attributes that to passing on of the overcharge down the chain. But in my submission, the way in which we have canvassed that playing out is consistent with what the court has said in Gutman about what's required of the methodology now. And I think we were just working through what's being said. We came to 56 issues not answers, which is a paragraph you've been drawn to previously. In my submission, that's supportive of the timing issue that I've flagged up. The CAD is concerned to identify the issues and gauge whether the methodology proposed for determining those issues is workable at trial when the issues are tested and might lead to different answers, some in favour of the defendants. Well,
I'm just pausing there and asking my question again. I mean, issues, so I'm trying to ask you to interpret my Lord's words, but...
I've no idea.
I mean, it's obvious there that the issues there are the issues to be determined between the parties, and does the methodology work for determining the issues that will arise for determination at trial, i.e. issues between the parties? And that necessarily must encompass...
My Lord, yes, so there is an issue
raised by the defendants if you know about them at the time of the certification process. No?
There is an issue between us as to the extent of any overcharge. There's no dispute that our methodology addresses that. There's an issue as to the extent to which the overcharge has been passed on down the chain. As between us there is an issue as to whether one must look at the delivery charge for the measure of loss suffered by the class, or one must look at the overall value of the car. And on that issue, our methodology has grappled with that by putting out our expert basis on which we say the answer to that issue is...
No, but can your expert methodology work whichever way that issue goes as a matter of law at trial?
Well, my Lord, there's no doubt that our methodology has chosen to advance a case based on the delivery charge. We have not sought to advance a positive case based on the value of the car. But in my submission, it is not correct to say that our methodology is faulty because it doesn't at the same time anticipate and address the counter case that will be put against us. In my submission, if you ask, does it have a real prospect of success? The real prospect of success, or possibly inaccurately...
Real prospect, provided you're right on the law.
Well, my Lord, it's a factually sensitive question. It's easy to say it's a legal question, but it's a question which turns on the facts, and we have adduced a methodology by which we can succeed on that question. It is, of course, right that we might not be successful at trial. That is, of course, right. And the tribunal has commented on that in terms of what the test requires, and it said the Microsoft test isn't so onerous that you have to advance a methodology which is guaranteed to succeed. And in my submission, if the criticism is you have to address not only the way in which you put your case, but advance a methodology in order to address the way in which the other side put it as well, in my submission, that's tantamount to saying we have to...
Surely you've got to produce a methodology which is workable for the tribunal. In other words, it's got to help the tribunal resolve the issues or determine the issues at trial when those issues might go one way or the other.
My Lord, yes.
So if a methodology doesn't or isn't either adaptable or doesn't in fact address both possible outcomes, is it in fact is it fit for purpose, to use a different expression?
Well, my Lord, our submission will be our methodology does do that.
I think it's a similar point in Merrick's. I haven't got the paragraph in front of me, but there's a point. As I understand it, what you're saying is there are two counterfactuals. One where you just simply look at the global price, that's the defendant's case, and you say the counterfactual is one where there are two things being considered. One, the global price, save delivery charges, and delivery charges. And if you're right, then you've established your counterfactual at trial. If you haven't, you lose. And in Merrick's, the Supreme Court said there may be some methodologies which just simply lose.
My Lord, that must be right.
But But the question then is whether you now required at this stage to address the alternative counterfactual which is put up against you, or whether you simply take your chances and win or lose.
And my submission on that is we would be entitled to take up chances, win or lose. The tribunal has said that and it's right to say so. But in fact, we are not quite in that position in the sense that Mr. Robinson has indicated that in certain circumstances he would be able to take into account some of the factual matters that the respondents are now advancing. And so I'm not.
The Microsoft test does seem to suggest that the credibility is what Justice Rothstein says is methodology must offer a realistic prospect of establishing loss, so that if the overcharge is eventually established, then you can deal with the damages. So that's assuming, if you like, that the claimant wins.
My Lord, it may be that brings us back to the context of Microsoft, which was a situation where there was an overcharge at the top of the supply chain, and what they were grappling with was whether or not you could show that it had been passed down the supply chain to the class. And so when they're saying if an overcharge is eventually established, they're then saying, do you have a basis then to show a common loss? I'm just trying to find the actual wording of the text.
Yes, it's page 870 in the bundle.
Yes. A realistic prospect of establishing loss on a class-wide basis. Yeah. Yes, there is means by which to demonstrate that it is common to the class, i.e. that passing on has occurred.
Can I just pick up one point? You said a couple of times now, I think I did pick it up the first time, that Mr. Robinson said that if something, a point was put or it came up that his methodology would be able to accommodate it. I don't think that's actually what he does say with respect. I think what he says is, and I'm reading 414, if during the course of proceedings the respondents were to introduce evidence which contradicts the assumptions of the industry experts on which my analysis is based, I would consider how this may change my approach.
Your Lordship is quite fair, and I do want to come on to show you the passages that Mr. Robinson deals with this. In my submission, that is sufficient. It is not necessary or any part of the Microsoft.
He's just saying, I'll think about it. He's saying, is he actually saying I can deal with it, or I've already factored it into my design of my methodology, or is it just that I haven't considered it at the moment? I will do in some point further down the track.
Well, my Lord, there are some examples, and I'll come on to show you, Lordship, where he goes further and he gives specific examples.
Okay.
Of this is how I can adapt my methodology. So there are,
right, okay.
And we will also see that the tribunal, when having assessed the methodology, was satisfied that it was one that was sufficiently flexible to accommodate these sorts of things.
Okay.
I do say that there is a point of principle here, which is that at this early stage, there is a limit to the extent to which a class rep can be criticised for not having anticipated and done the process of adaptation now. And this comes back to the timing point. In my submission, the test, as we see here, is essentially asking, by the time we get to trial and over the course of that process, is this methodology going to enable the tribunal to grapple with the issues at trial? And we could perhaps just pick up the last few paragraphs. We were looking at, I think, 56. CAT is concerned to identify the issues and gauge whether the methodology proposed for determining those issues is workable at trial when the issues are tested and might lead to different answers, some in favour of the defendants. Because of this, the CAT will wish to assess whether, if the defendants do win on some issues at trial, the methodology is capable of being adjusted so as to reflect only partial victory by the class. In my submission, that's consistent with what I have been saying. It doesn't have to demonstrate that it has in fact been adjusted by the time of the CPO.
Or even by trial?
Well, certainly, in some of these paragraphs, what's envisaged, and we'll come on to the paragraph about the broad acts, what's envisaged is that the CAT itself is able to direct adjustments that it might think appropriate. That's actually is paragraph 58.
Yeah.
And we see there, and this is consistent with what the Supreme Court said in Merrick's, that the court must do its best on the information available, so that the court has a role here, and the CAT can wield the broad axe to facilitate the vindication of claims. And what's said in this paragraph is that the axe is an expandable axe. It's a broad axe by which it can fill gaps and plug lacunae in the methodology. The axe head is adjustable and can expand and retract to meet the nature of the case. This is the axe being well wielded by the cat. And this paragraph does specifically comment on the situation of an indirect pass-on case at the end of this paragraph, beginning, however. It says, in a claim by, say, indirect consumers in a pass-on case, the amount of available hard data might be far less at the certification stage, and indeed throughout the proceedings. The cat might therefore be less demanding at the certification stage, and the knowledge that the axe head can be expanded to facilitate the achievement of practical justice at later stages of the litigation. So, in my submission, the court is here envisaging a role for the cat in ensuring, throughout the proceedings up to trial, that it does the best it can on the information available, as it has been directed to do by the Supreme Court in Merrick. Similarly, we see in paragraph 60 over the page, the test is about practical justiciability. And we see again at the end of that paragraph, we agree that a central consideration for the cat when scrutinising a methodology under the Microsoft test is to decide whether it's workable at trial, but always bearing in mind that the cat has the power to wield its broad axe and work in a relatively rough and ready way with assumptions and common sense intuitions, and that it can permit or even require adjustments to the methodology prior to and at trial. That, my lord, is the passage that I was referring to, that the cat can actually mandate, should it feel appropriate, that the methodology be adjusted to reflect the way in which the proceedings have evolved. Paragraph 61 is the paragraph that the respondents like, because it indicates that the test is not one which is toothless. We then come on to paragraph 65, which concerns the nature of the appellate review by this court on issues of law. And what we see, in about halfway down, beginning in an area, is that the court perceives this as an area where this court accords to the cat a broad margin of judgment and discretion, and the fact that the challenges to the cat's evaluation of conflicting economic evidence, which involves a forward-looking counterfactual assessment of how issues will unfold at trial after disclosure, means that the hurdle for showing an error of law is high. That, in my submission, is consistent with what the court had already said about its appellate role in the Patterell, and that's in the authorities bundle at tab 23. It's the first tab in this same bundle.
It largely flows out of Sainsbury's and out of Merrick's, I think.
My lord, it does. It's all entirely consistent.
So we're going to the Patterell now, are we?
The Patterell, just briefly to comment on the nature of this court's appellate role. Paragraph 55 is the paragraph that I referred to earlier, where the court says, on the basis of merits, that the overall high-level approach that the cat should take is treated as an issue of law. And the examples they give there are the interpretation of section 47C2 on aggregate damages as a departure from the compensatory principle, and the requirement for the cat to take the broad brush, broad axe, do the best you can approach to issues of evidence and quantification. We then see at 56, partway down, the exercise of judgment over facts can on occasion amount to an error of law, for example, where the decision in dispute is outside the generous bounds of that which the decision maker, here the cat, could properly and reasonably make. And the example here is quite an extreme one. If, for instance, the cat were wrongly to place the decimal point one place to the right in an equation relevant to the computation of aggregate damages, thereby magnifying the damages to be paid by 1,000%, then the court might, for example, treat this, for instance, as the cat taking into account an irrelevant consideration and correct it. So that's a fairly extreme example of a situation where an exercise of judgment might be reviewable, but the court says we consider that issues such as this will be very much the exception and not the rule. And we come on to 57. On the other hand, when it comes to the weighing up of the various factors relevant, and in this case, this is a case to do with opt-in and opt-out, so they say here, relevant to the choice of opt-in or opt-out, this is essentially an exercise of judgment over facts and evidence by an expert specialist body that will over time accrue an increasing well of experience in how to handle these complex cases. And at the bottom of the page at H, this court should not interfere simply because it might, for the sake of argument, have drawn a different conclusion from the weighing exercise. We would expect that most opt-out, opt-in decisions will involve a weighing exercise of this nature. And we've seen that although the weighing exercise the court's talking about there was opt-in, opt-out, paragraph 65 in Goodman was saying that the same is true when the CAT's assessing the adequacy of a class representative's methodology.
Well, I think we're quite used to hearing appeals from specialist tribunals which are limited to questions of law, whether they're tax tribunals, immigration tribunals and so on. And
it may be that it's all familiar ground, Your Lordship. I'm moving on to deal with our methodology. And as the court's aware, these are follow-on claims based on the decision of the European Commission finding a cartel in deep-sea shipping. And we know that there's no challenge to the methodology for overcharge. And so the focus of the appeals is the methodology for ascertaining whether the overcharge is then passed on. And the court has heard that we rely on two bases of evidence for that, the expert economist evidence and the industry experts. Starting with the industry experts, their report is at Supplemental Bundle tab 6. It's worth just noting their experience before I show you the substance. If we look at paragraph 1.2 on page 231, you see summary of Mr. Goss's experience. He's currently chairman of Virtue, the 5th largest motor retailer in the United Kingdom, and he previously worked at Toyota, Porsche and Jaguar Land Rover, in each case holding very senior roles, and he has over 40 years experience in the industry in total. Paragraph 1.6 is the beginning of the summary of Mr. Whitehorn's experience, and he's now a consultant to the automotive industry, and he has his own company, but he's previously worked at Toyota and Hyundai. Again, very senior roles, President and CEO of Hyundai UK. So in our submission, there's substantial experience, and these experts are very well qualified to express a view as to how things work in practice in this industry.
yeah.
Paragraph.
He deals with pricing at 223, and then he deals with delivery charges at 227 and 228.
Your Lordship's quite right. I was actually going to show Your Lordship the diagram at 3.3. And this is a diagram which shows the components of a vehicle's delivery charge. And you can see it starts with the OEM's costs, and they include shipping costs as the third item on the list plus a margin. They're then passed to the national sales company, and those costs include the OEM's cost plus a margin. And those are then passed to the retailer, and the retailer's costs include the national sales company's costs plus a margin. And that's the composition of the delivery charge. And you see at 3.4, delivery charges reflect the actual cost of delivery of a new vehicle in the process summarised at paragraph 3.3 above. They say while the process may vary slightly by OEM, the underlying principles of how the delivery charge is arrived at is the same. And what happens in the following paragraph of the report is that they then address each of the three stages, OEMs, national sales companies and retailers. 3.5 to 3.7 are dealing with OEMs, and they explain at 3.6, OEMs charge the NSCs a price which includes the cost of the vehicle, insurance and freight plus a margin. The element we're concerned with here is freight, which is the cost of transporting the vehicle from the factory to the local market. And they specifically say here at this stage, the delivery cost of the vehicle is itemised separately. So that's the evidence for the proposition that at the OEM level, this is a separately itemised charge. We then see at 3.7 that the cost will often vary by model. Where the same model is manufactured in more than one location, the OEM will charge the NSC a single blended cost for that model rather than charging the NSC separate amounts depending on where the individual vehicle was manufactured. So that's the OEM stage. We've then got national sales companies at 3.8, and they bear, at point A, in 3.8, the charge imposed on them by the OEM to get the car to the NSC's country, as described at 3.6 above. Just going over to the page to 3.10 and 3.11, this is how the OEMs, the NSCs set their delivery charges, and they under 3.10a, calculate their total projected logistics costs, both the costs incurred and recharged by the OEMs and their own costs. They divide the projected logistics costs by the total projected unit sales to calculate the average cost of delivery per vehicle. And then they add their margin. And they say at 3.11, in our experience, recommended delivery charges are generally the same across all models of a particular brand. Turning over the page, 3.13, they say in practice the NSCs will not consider all components of the delivery charge in forensic detail. They would take a more broad brush approach, with the main objective being to ensure that the input costs of delivery are recovered in full. And they say they'll monitor the costs on an ongoing basis. 3.14 explains that where it looks like the recommended delivery charges are no longer sufficient in light of the level of costs that needs to be covered, delivery charges will be adjusted upwards accordingly by the NSCs. If an NSC's costs fall, however, delivery charges will generally remain static. 3.16 says that delivery charges are often separately itemised on sales literature and or on the customer invoice. And they go on to explain the situation where they're not. Where the delivery charge forms part of the total on-the-road price rather than being separately itemised, the process is generally similar, but with additional on-the-road costs, such as VED, being added to the average cost of delivery per car before margins are applied and the prices are rounded as necessary. And they go on at 3.17 to address in my submission both the scenario where you've got an itemised charge and the scenario where they say the process is generally similar. They say, in our experience, it's highly unlikely that OEMs and NSCs would not recover, at a minimum, their delivery costs in full. The automotive market is very competitive and margins are extremely tight, so it would be unfeasible for OEM and NSCs not to recover the actual costs they incur. As it is accepted as industry standard, there is no need or incentive for NSCs or, by extension, retailers to absorb these costs or offer any discounting. 3.18 is the third stage, the retailers.
Sorry, what's the bit in brackets, 317, or by extension retailers? What does it mean by that?
In my submission, it's referring to the scenario, the facts on which they're making the observation that it's highly unlikely that they would not recover their delivery costs in full. So you see them point out the competitiveness of the automotive market, margins are extremely tight, and they say it would be unfeasible for OEMs and NSCs not to recover the actual costs they incur. As it's accepted as industry standard, there's no need or incentive for NSCs or, by extension, retailers to absorb these costs or offer any discounting. So what they're, in my submission, what they're saying is the factors they've identified apply equally to retailers. There's no need or incentive for them to absorb these costs or offer any discounting. And that's confirmed in my submission by what they say at 3.18. Delivery charges set by the NSCs are only recommended, as an NSC cannot dictate what a retailer will charge. In our experience, it would be rare for a retailer to discount the delivery charge, as there is no customer expectation to do so, and margins are such that it would not be commercially viable. And that's the origin of the reference to rare in the tribunals.
I mean, the point about no customer expectation to do so, that assumes that it's separately identified. And if it's not separately identified, then, in a sense, if the customer's only faced with a global price, an on-the-road price, without a line entry, then, well, as I understood this evidence, is if you have a delivery charge that is identified as such, the customer would not try and negotiate that away. Whereas if there is no separate identification of it,
we can come to what Mr. Robinson says about this, but as he explains, one has to look at it both from the perspective of the customer and from the perspective of the retailer. And your Lordship rightly puts to me that from the perspective of the customer, if there is not a separately identified line item, then it's unlikely that the customer will focus on such a line item because they wouldn't know it was there. But the other dynamic that is working here is the position of the retailer, who has, as is explained, extremely tight margins. It's industry standard, it's accepted as industry standard that there's no need to absorb these costs or offer any discounting. And so from the perspective of the retailer, there is no reason for them to negotiate away that proportion of the charge. And they do come back to this in their second report.
Can I just ask you, I'm not quite sure that I understand. If the object of the exercise is to assess the loss suffered by the customer, why do you have to look at it from the retailer's point of view?
We are here assessing the extent to which the respondents are right to suggest that you have to look at the price of the car because there is a risk that the way in which a customer negotiates will in some way prevent the charge from being passed on. That's the factual proposition that we're looking at.
Is the object, well, let me put my question a slightly different way. Is the object of the exercise to determine what loss has been suffered by class members as a consequence of the unlawful cartel?
Yes.
That's what we're doing.
Yes.
So we ask, what loss has a customer suffered because of the cartel? Why do we look at it from the retailer's point of view if we are looking at what loss the customer has suffered?
Because this explains why it is not right in our submission to treat the entirety of the price of the car as a completely fungible pot of money from which the retailer may agree to negotiate with the customer a discount. In our submission, this is obviously fundamentally factually in dispute, but in our submission based on our evidence, that is not a correct characterisation of the price of the car because there is this separately identified charge which represents a cost to the retailer, as a consequence of which the retailer is not incentivised and is highly unlikely to discount that cost, and therefore that cost can be traced down the chain and has been borne by the class member.
This is your case, there's two silos, not one. One of the silos is the delivery charge, and the other silo can take account of the defendant's case. You say everything else which goes into the price of a car, but this is the pressure, you say, the economic pressure which leads to your inference that delivery charges are not negotiated away and they go 100% down to the consumer.
This is the
You're just describing the economic pressures
yes.
down the line which lead to that conclusion.
Yes.
Then you draw an inference from that.
Well, it is actually more than an inference because we'll come on to see that the view of the industry experts is that it is borne by the end consumer, and they're quite clear that that's their evidence, and that's what happens.
But, I mean, the retailer may choose to explain it away to itself as not discounting the delivery charge and perhaps explain it away as just accepting less profit on the sale. The customer may see it completely differently. I mean, hence my Lord's point. I mean, the customer faced with £21,000 as the list price, who gets it down to 20,000, let's say, doesn't care whether that's as a result of reduction of something which the dealer may never have told him is a delivery charge. But if you actually explained it to him, he may say, well, yeah, I got a discount on that bit of it as well. You know, I got a pro-rata discount across the entire price. I mean, how the dealer chooses to sleep easy at night by telling himself he's not discounted the delivery charge, you know, absolutely not, I never would. Why does that matter?
Well, my Lord, the fact that you're putting this scenario to me in my submission demonstrates that this is a fundamentally factually sensitive debate as to whether or not we are right that because the retailer silos this cost, they ensure that that's passed on, however they then sleep at night in terms of the deductions, or whether we're wrong. The very fact that we can have these debates.
But you say as a matter of law and fact, I mean, there's two questions, but you say you just ignore the discount, do you? That any discount that's negotiated, you can just say you're entitled to prove your case on the basis that there's no discount to delivery charge. It's full stop, end of story, that's it. Don't need to look at what happens as between retailer and customer.
We say that if this evidence is made good, then this is enough to show that that particular identified charge has been passed down to the class. And in those circumstances, whatever might be negotiated as to the overall price of the charge doesn't prevent that itemised individualised charge from being passed down to the class.
So says the retailer.
So say the industry experts. And
No, they say, so would say the retailer.
they do say that, and we'll go back to the evidence that Mr. Singler showed you from Mr. Dent, who is a retailer, and it's, in my submission, entirely consistent. But in my submission, the very fact that we are having these debates and considering these various factual scenarios underlines that this is a hugely factually sensitive question. It's not appropriate to say now.
Did you say on this basis your methodology just doesn't need to go into that at all?
I say that we will come on to the extent to which the methodology is capable of accommodating changes in the evidence, because we don't accept the characterisation that it is excessively rigid and it can't. Okay. But certainly, in terms of what this is doing, this is putting our positive case on the basis of which we say we have a real prospect of showing common loss to the class and satisfying, therefore, the test. We got to, I think, 3.18.
Yes.
3.19 makes the point that NSCs at a minimum seek to maintain a fixed profit margin in respect of delivery costs in line with their business planning and budget assumptions. So this is, again, the margin maintenance point. And if we go on to 3.24, this is the passage that I was referring to in my exchange with my Lord Snowden. This is where they say categorically, in all the purchasing and financing scenarios we have discussed above, delivery charges are borne entirely by the end customer who is purchasing or financing the new vehicle in question. And they go on to address the different scenarios. And you can see 3.25, it's generally recognised across the industry that the final delivery charge will always be applied. This is primarily because delivery charges are a separate line item applied to the invoice at the point of sale.
But suppose somebody goes into the car showroom and they see a car at a certain list price and they want to have a little negotiation. And the dealer says, all right, I'll chuck in the number plates and the vehicle excise duty. They pay. How do you deal with that?
Well, one would need...
Your experts say it's treated in the same way as the delivery charge.
One would need to have evidence as to the way in which those items of costs are...
Well, vehicle excise duty is a cost. I mean, that's the government sets it, and whoever buys the licence pays it.
My Lord, I hesitate to speculate because our case is very much premised on what we have been told by the industry experts. The industry experts are quite clear in relation to this particular item of cost that we are concerned with, which is the components of the delivery charge, that those would not be negotiated away, they would be recovered. And so that is the basis.
The customer says, well, I don't mind paying the delivery charge if you chuck in the vehicle excise duty in the number plates.
We do have a... When we come to see what Mr. Robinson says about the way in which negotiations might impact this, he does consider the specific circumstances of where a negotiation actually focuses on the delivery charge. Because that is the one scenario where he says, okay, well, I can see that in the factual and the counterfactual, if you specifically focus on the delivery charge, that might cause a different outcome. But he points to the evidence deriving from the respondents, which indicates that that happens extremely rarely.
It may come back to the way in which you calculate aggregate damages and the principles of waiver of tort, that the case law, particularly the Canadian case law, recognises there may be quite a large number of exceptions to the rule, but you don't have to build those exceptions into the rule for the claim to succeed. It's an aggregate, globalised and rather generalised assessment, recognising there are a huge range of permutations of actual loss. And I think that's wrapped up in the principle under 47B about aggregation.
My Lord, that must be right, and I believe I'm right in saying that the particular example Mr. Robinson gives is that you could make a deduction across the board of the aggregate damages to reflect the extent to which the customers are fleet customers who might be able to negotiate away.
I think we had that in Goodman as to what happens if the CAT makes an estimate that, let's assume they simply say, well, on the evidence we think there was some negotiation, we're going to round it up in favour of the defendant and call it 1.5%. And then we're going to apply that across the entirety of the damages claim to soon reflect uncertainties as to precisely what happened and to reflect the fact that the sections 47B, when you have aggregate damages, you will carry into the class those people who may have suffered no loss and who are nonetheless going to be compensated. So you find a way of accommodating that.
My lord, you do, and that was one of the things that your lordship dealt with in your Gutman judgment, that the possibility of having suffered no loss is something that will be dealt with at some point. You must winnow them out at some point.
At some point.
Process. Indeed. And this, in my submission, is a similar process.
And I think it's really something which flows almost inexorably from the fact we're dealing with aggregated claims, because particularly when you've got millions of claimants and you're not examining the individual circumstances, it's impossible to say that some people may have suffered no loss, some people may have suffered more than the average, but you're trying to find an aggregated figure,
My lord,
which
yes.
necessarily assumes a degree of rounding.
And that must, in my submission, be what is meant when we ask, well, can this methodology accommodate this? Can it make a sensible adjustment to the aggregate figure to reflect the way in which the evidence eventually comes out? And my submission will be that what Mr. Robinson says makes clear that that is a perfectly viable possibility in this context. I'm just going to show the court 3 passages in the industry expert's second report. This is supplementary bundle tab 15. Second supplementary bundle. So starting at page 390, you see the heading delivery charges from NSCs to retailers, and they identify that they're responding to a query. The MNW response states that the first industry expert report does not make clear whether NSCs charge itemised delivery charges to retailers, and if so, whether any delivery charges are model specific or charged on an average basis across all models in a brand. And they confirm at 3.6 NSCs do charge retailers itemised delivery charges. This is a fixed charge and there is no negotiation between the retailer and the NSC. So just pausing there, we've seen in the previous passages that I showed you that they have confirmed that delivery charges are itemised at the OEM level, and they've commented on the extent to which they're itemised at the retailer level, and this is essentially filling in the gap and saying at the NSC level they're also itemised. So we're dealing with a charge which is itemised down the chain. Then at 3.9, they say, in our experience, NSCs would not absorb any increase in delivery costs. There is no expectation they will do so, and they operate on such tight margins that costs must be passed on to ensure the ongoing viability of the business. That's consistent with the points they've made in their first report. And then at 5.9...
5.9.
5.9 at page 398. This is the passage that I referred to earlier, where they are specifically commenting on the nature of retailer margins. And they say the margins are percentages of the basic price of a vehicle to which on-the-road costs such as taxes and delivery are then added. This means that even if a retailer was willing to give up all of its margin in order to agree a sale, the delivery charge would still be added on and would not be subject to any discount. As described above, in our experience, a retailer would not discount or absorb the delivery charge, as this would be a hard cost to the retailer, not an erosion of the retailer's margin. This is the origin of the use of the term hard cost in my submission earlier. And what they're saying here in my submission is that there is a relevant distinction between a margin which the retailer might be willing to negotiate away and this particular cost element which they describe as a hard cost, and they say that a retailer would not discount or absorb the delivery charge. So in our submission, the industry expert evidence does 3 important things. First of all, it tells us where any overcharge arising from the cartel in deep sea shipping is to be found, because it tells us that shipping costs are one component of the delivery charge. And secondly, it tells us that delivery charge...
Sorry, can I just pause? Those paragraphs you just showed us, I just want the context. Is this all about whether a retailer can show to the NSC that it's making and hitting some target, some margin target, or whatever? In other words, is this all looking at how NSCs and retailers sort of interact?
I had not.
I'm just trying to understand the context of these comments about margin and erosion of retailers' margin. I mean, a customer doesn't really give a stuff about retailers' margin. He's just interested about how much he's going to pay for the car. This is all to do with how a retailer interacts with an NSC, which may have a view as to whether it's a person who should be selling his cars or not.
My Lord, yes, just to give your Lordship the context, he's responding to Mr. Dent's witness statement. If we go over to the previous page 397,
Yeah.
he's saying, at paragraph 20 of his witness statement, Mr. Dent describes that dealers, brackets retailers, have target margins, and he describes 14.5% as typical in the industry. We believe this is a point which needs clarification, and they comment on the extent of the margin at 5.7. And then 5.8, they say it's important to note that the target margin comprises a metal margin, which is typically around 8 to 9%, and a holdback margin, the remaining 4.5%, which the NSC pays to the retailer if it satisfies certain criteria. A retailer cannot consider the holdback margin in negotiations with a customer as it's not guaranteed. A retailer's room for negotiation is therefore limited to the 8.9% metal margin. And then in that context, they go on to explain why a delivery charge is different from the margin. It's not available to be negotiated away with the customer.
Isn't this just all how the retailer will account for its own internal purposes, or explain itself away to the NSC? I mean, I'm just struggling to understand how this relates to the customer, who's the claimant in these proceedings, and how it relates to the customer's experience or the customer's loss.
In my submission, it goes further than any sort of accounting to the NSC, because what they are saying is that the effect is, in their experience, a retailer would not discount or absorb a delivery charge. And so the reason why it's relevant to the customer's experience is that the customer will have borne the delivery charge and so will have borne the overcharge. And that is the class representative's case based on this evidence.
And you say that's the end of the inquiry?
We say that this is the basis of the methodology which satisfies the test for some basis in fact, and again I'm paraphrasing the relevant test.
Yes.
But we say that this is in our submission clearly sufficient factual basis to satisfy the Microsoft test.
Full stop or at this stage?
Well, my lord, the Microsoft test only applies at the CPO stage.
It will be, well, subject to whether it contemplates that the methodology might change. Certification, yes. Certification can be revisited. And if it evolves, and say, for example, your theory became ever more adventurous, the tribunal might say, well, we'll revisit it rather than now that go to trial. But it's not, I don't think it's necessarily fixed in time.
Certainly that's consistent, my lord, with the submission I made, that this is an ongoing process. Obviously, this is a new regime, and we haven't yet encountered a scenario where the tribunal has sought to reopen a certification. I certainly wouldn't want to speculate as to the circumstances in which that would happen. But the point being that presumably it would occur in the light of the way in which proceedings evolved, as opposed to at this stage, at the outset, where the representative is being asked to provide a methodology by which they say the commonality of the issue of loss to the class can be addressed.
Yes, I suppose pragmatically the tribunal is unlikely to revisit what it's done already. It may say we'll keep a weather eye on this, or we'll look at it after disclosure or after witness statements, for example.
My lord, yes, and it would be potentially problematic in terms of the efficacy of the regime if it were open to respondents to keep seeking to reopen in the absence of a material change in circumstances.
Yes, one can assume the CAT's case management powers would prevent that sort of misuse.
My lord, yes.
Yeah, so it's saying this tells us three things. The first is that where we find the overcharge.
My lord, yes.
The second is that the delivery charge was something, but you stopped before you got to the end of that sentence.
I apologise, my lord. The second is that the delivery charge is generally separately itemised throughout the supply chain, the OEM level, the NSC level, and the retailer level to the end customer. And in an exchange with Ms. Demetrio, your lordship, you asked, well, does that matter? And Ms. Demetrio's response was, well, no, it doesn't. From the respondent's perspective, they say it doesn't matter because their perspective is that you have this essentially value of a car, and all of that money is essentially up for negotiation as and when the retailer negotiates with the customer. In our submission, on the basis of our industry evidence, yes, it does very much matter, because it is one limb of the reason why in our submission we say that there is this separately itemised charge which is preserved and passed down the chain and is in fact passed on to the end.
Are any of the costs separately itemised, or is it just delivery? I mean, if it's only delivery, one perhaps does ask why only delivery. Might suggest it is being treated separately. Are other costs separately itemised?
I hesitate to give an answer on my feet on
Vehicle
that.
excise duty and number plates are two, which your experts talk about.
I'm grateful, my lord. Certainly we say it's enough that this one is, and we say it's a sufficiently material distinction. It takes us away from the scenario that the respondents are advocating,
What about-
is that you have this fungible pot of money.
Dealers add their own extras sometimes.
My lord, it may be that they do. If it's at the dealer level, we are not talking about a charge which has been separately identified and passed down the chain, because that's essentially the key element here, is that it comes from the level where the cartel overcharge is, and it gets passed down.
I suppose you say this is just one part of the evidence that Goss and Whitehorn have referred to. Their own experiences that it's passed down, which is consistent with itemisation.
It is consistent with itemisation. They obviously, their rationale for why it happens is not limited to itemisation.
No, of course,
in
no.
the sense that they explain that it's the economic drive.
Yeah. But you're not relying upon itemisation in isolation to prove the case. It's just one out of a number of circumstances.
My lord, yes, that's right. The third important factor that we say comes out of this evidence is that it tells us that it is industry standard, and that's the words that they use, for the delivery charge to be passed on to the end customer, and that the retailer would not discount or absorb the delivery charge because it's a hard cost to them and not simply an erosion of their margin. And that's the other piece of the puzzle in our submission. That's why it matters, because this is not just a fungible pot of money on the basis of which the retailer and the customer negotiates. There is a separate charge which the evidence is not discounted or absorbed. It is passed on. That is their evidence. And we do say that what the industry experts say about the delivery charge is consistent with the evidence adduced on behalf of K-Line that you've been shown. There's a supplementary bundle, tab 14. And this is Mr. Dent, who's a retail sales leader at Stratton BMW. And in particular, if we look at paragraph 27, this is one of the paragraphs that you've been shown already. He's talking about the delivery charge, and he says, I tell customers that the delivery charge is included in the advertised price and cannot be discounted. He then says, on a number of occasions, and in brackets, 4 to 6 times a year on average, so really a very limited number of occasions in my submission. He says, I have had customers who have specifically focused on that cost and said that they would not buy the car if they had to pay the delivery charge. And then he says, the system does not allow me to change the delivery charge from £825 to 0. And he says, I could achieve the same effect by putting an additional amount of GB 825 in the special allowance section of the invoice. Now, of course, what... He says it makes no difference to a dealer where the discount is applied. It is, however, physically impossible to change certain line items. Now, in our submission, that is entirely consistent with what the industry experts are saying, because they are saying there is this separate charge, and here is Mr. Dent telling customers it's not up for negotiation, and he can't even change it on the system. This is the evidence on which Mr. Robinson then bases his quantitative methodology. And you've been shown a fair amount of that already, so I can take it very quickly. If we look at Supplemental Bundle tab 7, starting at page 310.
What page?
310,
310.
yes.
Yeah.
So 5.23, he explains that what he's considering is the difference between the delivery charge in the but-for scenario when there's no cartel and the actual scenario when there was a cartel. And at 5.26, you see him explaining that he faces a practical difficulty. And that's because he says it's unlikely that the composition of the total delivery charge, i.e. the breakdown of shipping costs, other costs and margin, is going to be observable by me, as such information is not publicly available and disclosure from the proposed defendants would only provide information relating to shipping costs. And he says, however, the principles outlined above indicate that the details of the mix of the OEMs, NSCs and retailers, other costs and margin where relevant will not be required in measuring the overcharge to the end customers. Rather, the process I would propose to adopt to quantify the degree of overcharge, which was passed on to the proposed class, is as follows. Just pausing there, the submission was made by Mr. Singler that no part of Mr. Robinson's approach was driven by data issues. But in my submission, what he's explaining here is very clearly that he's turning his mind to the potential limitations of the availability of the data. And he's saying the actual composition of the cost is not going to be observable by me. And so this is why I'm adopting the methodology that I am.
Is this his response to Dr. Mudenbar's complaint that you don't actually address this category of evidence that Mr. Robinson is saying is impossible to get his hands on?
This is not a responsive report at this stage. This is the first report that he's put in. But even at the outset, he's saying, I'm thinking about what...
The issue coalesces, doesn't it? Is that this is the issue that Dr. Mudenbar was referring to, this type of evidence, if I recall.
I'm afraid I'd have to go back to check with the actual paragraph that your Lordship's referring to see which
Don't worry.
he's referring to. But certainly what Mr. Robinson is very conscious of is that he has to put forward a methodology which grapples with the data limitations that he's identified.
Well, Messrs. Goss and Whitehall are talking about delivery charges, and that's the entire charge from factory to retailer to customer. And Mr. Robinson now has to isolate from that delivery charge that part of it which is the overcharge attributable to the cartel, and this is how he proposes to do that.
My Lord, yes, your Lordship has it.
The point's made clear over the page in 529. He elaborates on that.
Well, Ms. Ford, when you get to a convenient moment, I think it's probably time to stop for the day.
My Lord, I could essentially finish off this report and then I will move on to the second report very briefly tomorrow. If that's convenient. He's summarised his approach in 5.26. He says he's going to measure the total shipping cost overcharge per brand. B, he says I'm going to divide the total number of vehicles registered with the DVLA to arrive at the overcharge per vehicle. I'm going to observe the next increase in the total delivery charge per vehicle levied by the NSC. I'm going to calculate the overcharge to the end customer as the smaller of the shipping cost overcharge per vehicle and the increase in the total delivery charge per vehicle. And so the point that's been highlighted already is that by taking the smaller number, he will never attribute an increase in the delivery charge to the cartel, where in fact it was caused by an increase in costs. Just to pick up 5.34 to 5.39, this is the paragraphs where Mr. Robinson comments on how he proposes to address the fact that some delivery charges aren't separately itemised. He says Appendix 8 shows that Mercedes-Benz, BMW and Volkswagen published the delivery charge separately. However, the Honda price list only provide a breakdown of the on-the-road price for the delivery charge, number plates and a tank of fuel. This is consistent with the point your Lordship was making about number plates and fuel and delivered and vehicle registration fee. And he says, I consider it's possible to calculate an estimate of the standalone delivery charge for Honda based on the average number plate cost and full tank of fuel cost as charged by other brands. And he goes on to provide an example. 5.36 for any other brands that did not show the delivery charge separately, but rather combined it with other on-the-road costs in a similar manner to Honda, it would be necessary to calculate an estimate of the standalone delivery charge in a similar manner. So that's how he envisages, from a computational point of view, assessing a scenario where there is not a separately itemised delivery charge. My lords, those are the points I wanted to draw out of Mr. Robinson's first report.
All right, well, we'll stop there and start again at 10:30 tomorrow. Thank you very much.